Your client was driving and vaping, and she's charged with intoxication manslaughter. I don't know what the conditions are, but she may not be leaving the courtroom today. If you want to file a motion to have the court reconsider that or bring some more information to me, Ms. Guerrero, of course, the court will be more than willing to consider that.
All right, buckle up. This case goes off the rails quick. We've got a woman charged with intoxication manslaughter, already banned from driving as part of her bond conditions. But guess what? She decided the rules didn't apply to her and got caught behind the wheel again. That's not just reckless, it's legal suicide. Judge Boyd doesn't hand out wrist slaps. When you openly defy bond restrictions, you're basically begging for the hammer to drop. And here's the kicker. Violating bond can actually add brand new charges on top of your original case, meaning she's digging herself even deeper. Watching her face when reality finally hits is something else. It's like watching someone realize the fire isn't just hot, it's burning the whole house down. So here's the question. Should bond violations ever get a second chance? Or is one screw-up enough to lock it down for good? Either way, let's dive right in and see how this one unfolds.
Okay.
It depends on what her conditions are.
Okay. Is there any way to set her up on a computer right now to talk to me in private?
Yes.
So I can find out what's going on?
The court has discovered from reviewing the filings. Yes, a motion was filed where this defendant was allowed to have the remote in-home monitor installed in the ignition interlock with an affidavit of non-driving. So she's not supposed to be driving because she's using it in-home. So what she has done is she's violated her conditions of bond. So she's driving and she's supposed to have, she's not supposed to be driving.
Okay. As far as I understand, I asked her about having a valid driver's license. I didn't ask her about the difference between the ignition interlock and the home handheld device. I'm sure that she would be more than amenable to have that ignition interlock placed on her vehicle. I do understand that there was an accident and her vehicle was not working, but maybe she has a new vehicle. I didn't get all those details, Your Honor.
All right, so that's what the court has, and that was dated on September 8, 2020. And the court doesn't have an order that's saying that she's going to be driving with ignition interlock. In my understanding, she doesn't have ignition interlock on her vehicle, and she should. So she's going to be going into custody today. She violated her conditions of bond. I can't have someone. And Ms. Smith, I don't take it as true that you committed an intoxication manslaughter, but you're charged with intoxication manslaughter. And one of your conditions was because your previous attorney came to me and informed me that you would not be driving. And so I allowed you to have the in-home monitoring device installed in lieu of ignition interlock if an affidavit of non-driving was provided. So you're driving and you don't have an ignition interlock. That's a problem. So you're going to be taken into custody today. Ms. Guerrero, she'll be remanded without bond. If you want to file a motion to have the court reconsider that or bring some more information to me, Ms. Guerrero, of course, the court will be more than willing to consider that. But for now, she is, I'm issuing a judge's warrant and she's going to be remanded.
Okay. Well, I'll visit with her tomorrow through the jail and I'll report back. Thank you, Judge.
All right, thank you.
May I be excused?
Could I have parties announced for the record for the state?
Jason Organs for the state.
Defense?
Monica, get out of this.
And are you Ms. Smith?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes,
The court will find that the state is in compliance with discovery. Ms. Smith, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the count 2 charge of manslaughter and waiving counts 1, 3, and 4.
No objection.
All right, Ms. Smith, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with the offense of manslaughter? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. They're waiving counts 1, 3, and 4. Punishments be assessed at 6 years in the prison and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
I don't get why she's crying. She knew exactly what she was doing. She didn't have the ignition interlock device, and she knew she wasn't allowed to drive. Let's not forget, her reckless choice already cost someone their life. These tears don't look like remorse. They look like an act. Courts don't accept oops as a defense when bond conditions are crystal clear. And in Texas, judges can stack consecutive sentences for repeat violations, which means every bad decision just makes the hole deeper. Honestly, I can't stand people like this. There are Ubers, taxis, buses, designated drivers, basically a buffet of safe options. With all those choices, driving drunk isn't a mistake. It's a statement that other people's safety doesn't matter.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. The state offers exhibit 1, the defendant's waivers and stipulation of evidence.
No objection, Your Honor.
Ms. Smith, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty.
Judge, may I clarify one of my responses in response to your question about motions?
Yes.
I said that I hadn't filed any, and I'm not sure if Ms. Corley did, so I don't want to represent to the court, because I think she may have filed some evidentiary motions. I did file some non-evidentiary motions, but I wanted to make sure that if Ms. Corley did, I didn't represent that there were none filed.
All right, and I can tell you from my review of the court's docket sheet that there was no motions that were heard.
Okay.
And there were some motions that were filed, but none that were heard.
I just didn't want to make any misrepresentation.
All right. So the court is finding you guilty of count 2. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
On behalf of my client, Judge, this is a case that was a tribal type case based upon the evidence that you reviewed. My client has made the decision to come in and accept responsibility for her portion in this accident that happened. She's extremely remorseful. She wants to get this behind her, and she wanted to say her apologies to the family that the area where this happened, the location was very dark, and she just didn't see that there was an accident in front of her. She has Graves' disease, and she's been pretty ill at the jail. So she's hoping that this time will pass, and hopefully that she can get her life back together. She was a home health care provider, and she did help a lot of people while she was out in the field.
All right, anything from the state?
We have victim impact.
All right. Anything you wish to say, Ms. Smith?
I'm sorry, please. I'm so sorry. I'm so sorry for what they lost.
All right, anything else from either side?
No, Your Honor.
All right, I'm going to follow your agreement. I'm going to sentence you to 6 years in the prison and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. So, Ms. Smith, there's going to be a victim impact statement. What I can tell you is I know that sometimes emotions and tempers run high, because in this court, we'll deal, as your counsel will tell you, and the state will tell you, we're dealing with serious cases, major felonies. But I do require that everyone treats everybody with respect and kindness.
She only got 6 years. Seriously? That feels like an insult to the victims. Why is it that when lives are lost, the sentences suddenly shrink? Is the justice system afraid to offend the guilty? And here's what really gets me. The state waived most of the charges. How is that justice? From where I'm standing, it looks more like a favor. She stands there acting remorseful, claiming to feel for the family, yet she wouldn't even plead guilty. That's not remorse. That's damage control. Real remorse isn't crocodile tears. It's taking accountability for the life you destroyed. And here's the kicker. Intoxication manslaughter in the US can carry up to 20 years.